Hi everyone, Eric from Envoy Global here with a quick message before the full video starts. If you had signed up and were watching during the LinkedIn live session, just want to apologize for the technical difficulties that we experienced in the middle of the event. We recorded the full event and it will be coming up shortly after this intro. Also, just want to remind everyone that if you aren't already, be sure to subscribe to Envoy Global's YouTube channel for more content like this, as well as other great video content coming out in the future. And with that, here's the LinkedIn live session on H-1B alternative strategies for 2024. Good afternoon, everyone. Apologies for the awkward start. We are live, but I cannot see the live feature, so awkward start today. But thank you so much for joining us. It is Thursday, March 28th. We have a great discussion ahead, talking about H-1B alternative strategies, and a lot of other great content coming ahead. But first, I want to introduce our guest today, starting with Matthew Neerman. Matthew, you are you are a senior attorney at Corporate Immigration Partners, and you are in Cincinnati. You mentioned we might be hearing a parade as of now, nothing yet, but yeah, Matthew, what can you just tell us a little bit more about your career and any other fun stuff?
Yeah, I'm a senior attorney at Corporate Immigration Partners Cincinnati office. Today is the Cincinnati Reds opening day parade. So if you hear parade noises in the background, that is the celebration for the start of baseball here, and it's a big deal in town. And as far as my career, I've been practicing immigration law since 2009, and mostly in the employment-based realm, to include H-1Bs, going all the way back to when we used to have to package them and send the cap cases out in big truckloads, at the start of every cap season. So we've seen plenty of successful H-1B cap filings, and we've been successful in providing alternatives for those who have not been selected. So we want to discuss that today and see if we can give people some ideas and some hope if they are not selected in the H-1B cap.
Thank you so much, Matthew. Moving out to West Coast, Peter, you are out in San Francisco and you are a managing attorney at Corporate Immigration Partners or CIP. What more can you tell us about your career as an immigration attorney, and then anything else you'd like to share?
Yeah, Eric, thanks for the intro. I've been at Corporate Immigration Partners for about 2 years now, and I've been practicing in this space for about 10 plus years, purely 100% business immigration law. Like Matthew, I'm a little dating myself. I remember the days too, and myself and my legal team and paralegals would package up physical H-1B petition filings before registration, load them up by the truckloads into FedEx boxes, and see, which of those cases got selected or not. So a lot of nights and days, at the big copy machines, doing a lot of copy jobs of H-1B petitions, and also, after selections, having conversations with foreign nationals and HRs about alternative strategies for folks who were not selected for the H-1B cap. So again, happy to chat about that today. I've got a breadth of experience with alternatives at anything from TNs to Os to Ls, and the whole gamut of the alphabet soup of visa categories. So happy to join today.
Awesome. Thank you so much, Peter. And also out on the West Coast, but in Los Angeles, Diane Haggiag, you are also a senior attorney at Corporate Immigration Partners. Can you tell us a little more about your career as an immigration attorney and any other fun facts?
Sure. So I've been with formerly Hammanil Moore, now CIP, for 3 years, almost 10 years in the immigration field. As you can hear, I was not born in the US. I came from France. I went to law school in France, then in New York, stayed in the US. And I've been through a lot of those immigration categories myself, starting as an H-1B student, actually F1 student, sorry, then becoming an attorney under an H-1B visa. And I think I can actually outbid everyone here. You may remember the packaging of the H-1Bs, but I remember not being subject to the lottery. That was a long, long time ago. There was a cap, but it was hardly ever reached. So got my H-1B pretty easily, then became spouse of L1, then green card, then naturalized citizen. So I started off in big corporate firms, but I knew deep inside that immigration was really my thing. And so that's what I ended up working in. I've been handling employment-based as well as family-based immigration applications. I've been handling non-immigrant visas, green card applications for a variety of categories. For the non-immigrant ones, I've been handling investors, E2s, L1 for multinational employees, O1 special talents, H-1B workers, and for the green cards, I've been handling green card applications for outstanding workers, professionals, unskilled workers, and multinational managers and executives. I also routinely do naturalization and marriage-based cases. And yeah, I'm in LA now.
Awesome. Well, thank you everyone for sharing your more about your careers, and we are going to hop into our conversation for today. I'm going to start with just a quick recap of where things stand with the H-1B cap, which Matthew, I believe they had extended it until Monday, which the date that was March 25th. That was correct? That's correct, right?
Yeah, they extended the registration period through Monday, this past Monday, at noon Eastern time, allowing people to get their last minutes H-1B's registrations in. Since then, they have closed that registration period out, and they have been rolling out selections starting around noon Eastern yesterday. We don't have any indication that selections have concluded, but currently we have seen registrations come through, submitted applications being selected through yesterday afternoon, a little bit over the nighttime hours Eastern time, and then we continue to monitor the selections as they come in until there is an email from USCIS saying that initial selections have been completed. We're going to assume that selections are still rolling. So there is hope for those who have not been selected, but there are people who are being selected or have been selected in the past few hours.
And can you remind us where people, employers, as well as petitioners, where they can go to see their status?
Our automated system will upload this status of a selected status to the Envoy platform, and inside of the Envoy platform, you will be able to locate the registration information, and also as it comes in, not instantaneously, but as it's collected from our automation center, it will be deposited into the Envoy platform.
Yeah, and I'll just add too, Eric, if the audience is not, using Envoy or subscribed to Envoy, generally speaking, these selections will show in the My USCIS accounts for the attorney of record and the HR or administrator who is the other person for the company in the My USCIS who did the registration. And you'll see the status say change from submitted to selected in My USCIS. So.
Gotcha. And then just for the group, if for those who are selected, what are the next steps starting April 1st?
So the selection notice typically will say like which service center or maybe even the lockbox that the petition needs to be filed at that it's being selected for, and it's a matter of really just again high level packaging the petition together, submitting the H-1B petition and sending that to where USCIS wants you to send that. And typically the window for doing that is about 90-day window. So just right before July 1st, folks who are selected have that opportunity to submit the H-1B petition.
Gotcha. All right. Appreciate the update on where things stand with regards to the H-1B cap, and I think with that we're going to move into the bulk of conversation today, which is discussing some alternatives to the H-1B. As everyone knows, Peter, the H-1B is very, very competitive. the 85,000 cap. What happens if companies were hoping to sponsor someone, but that individual isn't selected in this H-1B cap?
Well, I mean, I think that's the whole topic of conversation today. There's various different visa categories that I think we're going to dive into, Eric, and talk about if those foreign nationals qualify for that. Maybe even seeing if there's enough time to submit that foreign national for next year's H-1B cap. And just very high level, looking to see if they're a student, for example, looking to see if they can extend their student status either on OPT or STEM OPT, or looking at other visa category alternatives like the O1, TN, E3, H1B1, et cetera, et cetera. And I guess that's what we're probably going to do a little bit of a micro dive into, right?
Yes, yeah. So yeah, let's start with the OPT and STEM OPT, or sorry, OPT or STEM OPT. Peter, can you break down this alternative? What employers maybe should be considering if they do have someone who isn't selected?
Yeah, so for most folks who are on F1 student visa, OPT is an option for the folks to have work authorization for 1 year on OPT, and they would get an EAD card, and they can work for that particular employer for for 1 year. And then if they are graduating from a program that is STEM, so science, technology, engineering, or math, they can get an additional 24 months extension on their OPT as well. They can apply for that extension as early as 90 days before their current OPT expires. They would need to submit what's called a training plan, have that signed off by their current employer, submit that to their designated school official, get their I-20 updated with the STEM designation, and then with that particular STEM I-20 designation, they can then apply for STEM OPT. So again, it's not available for all particular, degreed individuals. It's really for people who are graduating with that, science, technology, engineering, or math degree. That's a common scenario that we would advise, employees to look at pretty early, because they want to make sure that they timely file for that EAD and OPT extension and not lose work authorization. So for example, if they're applying for the STEM OPT EAD extension, so long as they timely file that EAD renewal before their current OPT EAD expires, they get an automatic 180 days of work authorization beyond their current EAD expiration. So.
Great. Thank you so much. Then also just a quick reminder for those currently viewing or listening, if you do have a question for Matthew, Peter, or Diane, please go ahead and put it in the comment feature, and we'll do our best to address it. So Diane, moving to the next H-1B alternative that we wanted to discuss, the category of the L1s. There's the L1A, the L1B. Can you first start with just an overview of the L1 visa category and why, and just how potentially employers can use it as an H-1B alternative?
Right. So yeah, it is a non-immigrant work visa. So typically the employees, the candidates who have a bachelor's degree or who would be eligible for an H-1B are usually also competent to consider the L1, which is for a transfer of employees within a multinational corporation. So this is particularly appealing to companies in the US that have an office, a subsidiary, or an affiliate entity abroad. Only one is sufficient as long as there's the correct affiliation between the two entities. And so the US company does not necessarily have to be the parent, but the two entities can just be affiliated through common ownership. So the condition for a candidate to come and work in the US as an L1 employee is for that employee to have worked abroad for at least one continuous year within the past 3 years. So for that, from that perspective, it's very important to plan that type of visa early because of all the preceding conditions that are essential to meet the criteria. So the first condition, obviously, is the qualifying entity between the US company and the company abroad, the length of time the employee has worked for the company abroad, and the type of duties that the employee has had. If the employee was an executive or a manager, that makes him or her fall into the L1A category. And if the employee comes in the US with his specialized knowledge, then that would be the L1B category. So back to the L1A, the executive, how do we prove that the candidate is an executive? Naturally, we would prove that they're making executive decisions in their daily activities, they're not doing hands-on work, that they're supervising employees and making decisions without supervision themselves. For managers, the supervision of other employees is pretty important. And we also prove that through either organizational charts, memos, emails showing that they were directing other people within the organization. If there is a manager who does not supervise other employees, but who is essentially managing a function of the organization, that will also count into, they could potentially qualify for the L1A as functional managers. There is a higher scrutiny, so we have to be careful in how we improving those duties, but it is possible. If the L1A candidate is approved, he or she can get a visa for 3 years and can get extended for another 2 years, up to 7 years. So increments of 2 years, extensions up to 7 years. For the L1B category, it is actually up to 5 years total. And the scrutiny is also pretty high for the L1B employees with the specialized knowledge. Essentially, they have to be experts in a specific function of the organization or a special expertise in the product itself or the services or the processes of the organization. So a long time ago, those L1 visas were fairly easy, I would say, to approve. Nowadays, the scrutiny is pretty high across the board. So we have to be very careful in documenting those duties. The good thing about this type of visa is that it leads to a green card, and it has its own green card category. It's the EB1C for multinational managers and executives, and essentially the conditions are the same. So once the employee reaches the 7 years, if the company wants to keep that employee, they can sponsor them for the green card. So that's pretty helpful. The dependents of the L1 worker are also authorized to follow along in the US, and the spouse of the L1 is authorized to work automatically. So that's actually something pretty new and pretty helpful for the dependents. For larger corporations, there is a special category called the blanket L1, and essentially it is a former approval of the company of the organization, where for large corporations, the conditions are they have to either have 1,000 employees or 10 approved L1s in the past 12 months, or have a total revenue in the US of $25 million. If certain conditions are met, the company can establish the relationship ahead of time so that every future L1 worker comes in on a much faster basis, and the petitions are much easier to process. So if you're an HR of a very large corporation, that's something to consider. It's once the blanket petition has been approved and that the corporate relationship has been established, it makes it much easier to bring foreign workers. The consulates are pretty familiar with the process, and they're subject to much less scrutiny than smaller corporations. I don't know if you want any more details about the L1.
No, that was excellent. Thank you so much, Diane.
Okay,
just quick
sure.
follow-up. So with regards to the L1, is there a cap like we see with the H-1B?
No, not at all. There's no cap. I would say every visa category has its own challenges. So I would say for an H-1B, where all you need to prove essentially is that the candidate has the right diplomas and that the company has the ability to pay and that the offer is legitimate. For an L1, but then for the H-1B worker, they're subject to that huge uncertainty of the lottery. For the L1, it is much more complicated to qualify from the outset, but if you do qualify, then you can bring in as many workers as you want.
And follow up, does that mean, or does that allow employers to bring employers no matter the time of the year?
Right.
Or
Yeah,
is
they
there only certain
can.
parts of the year where they could bring?
No, whenever the company in the US is ready to bring in a foreign worker, they can start the petition. The 1 year employment will count 1 year before the entry into the US. So it doesn't match any particular fiscal or calendar year. It's just 1 year before the application. One thing I do want to mention too is if the company in the US is interested in bringing an executive from abroad, we have to be careful in proving that there is someone else to take over that role, because essentially you have to prove to immigration services that both companies will remain viable entities even after the departure of the executive abroad. So you have to be careful in showing that, yes, that person was an executive, they were very important, but also the company will remain viable because someone else will fully fill in for him or her.
Gotcha. Diane, anything else to add on the either the L1A or L1B?
No, I think actually there is a particular certain regulations regarding new offices, but I don't think it would apply to the audience. That would be situations where you have a foreign company, they want to set up a subsidiary in the US, and they want to send an employee to start that US entity. That's also subject to a particular scrutiny. And essentially, to open the new office in the US, the standards are almost as high as the investor's visa, because you have to show that the company has enough money to open a new office in the US, meaning a lease for a new office, opening the space, hiring additional employees, on top of all the other criteria that we have to prove, the employment abroad and the duties. You also have to show that the financial ability to open the US office and to run it properly. And for that reason, for those particular applications, the approval is for 1 year only. So essentially, because USCIS wants to see if the company is really operating, if the person qualifies, they would be granted 1 year. And after 1 year, they would have to apply for an extension and show to USCIS, yes, that office is really working and functioning.
Gotcha. Diane, a question just came in from the audience. Question is, the candidate must work for your company outside of the US for 1 year, or just any
Yes.
company outside the US for 1 year?
Oh, no, no, no. Your affiliated entity outside of the US. That's the whole point of that L1 category. We want to be able to transfer employees within the same group, within the same corporation.
Got it. Thank you so much.
Yeah, and to follow up on that, Eric, too. Sorry, just a quick follow up. So the L1's pretty common, I would say, as an alternative to H-1B. One thing that the company might want to consider is when they're offshoring that employee from the U.S. to the foreign entity abroad, they may need to look at the global visa as well as see if they have particular foreign national needs a visa to work in that country of that foreign, where that foreign affiliate is located as well. So something to consider.
Definitely, definitely. Appreciate it, Diane and Peter. Matthew, want to shift to talk about the O1 or the O visa. This is for individuals with extraordinary abilities. Is that correct?
That's correct. The O1A visa is what we're going to be speaking about today. There is an O1B for people that are entertainers and artists. That's kind of a topic for another day, but the O1A is designed for, it's flexible enough to be applicable to most careers for people who are of the top 1% in their field of endeavor. Some very nice things about the O1A, particularly if you are working with someone who is coming off of a J visa and they might have a requirement where they need to go home for a couple of years. The O visa is one way to at least delay the J visa requirements that you go home, with the catch being that you would have to get the O approval first here through USCIS, get a visa stamp, and then return again to the United States using the O visa. So if you have people who are here researching, working on the J visa status, O visa is one option to look at. The O visa is also convenient because it is flexible, meaning that many different types of careers can use it. The way that the O visa requires you to prove extraordinary ability lends itself to research careers primarily. So if you are in a career field in which you publish research, you're going to have a leg up in documenting your extraordinary ability in comparison to others in your field. Another way in which O visa is flexible is that you are not locked into a particular wage for the area that your worker is going to work in. So H-1B does require you to at least match the prevailing wage for the area for that career. O1 doesn't have that, although I will say that the O1 is trying to show that the person is at the top of their field of endeavor. So one of the ways that you can show that you are at the top of your field is that you are compensated higher relative to your peers. So, it can be flexible enough to use when you have some sort of wage criteria that is below, what it might be. But basically, the higher the wage, the better. You can use that as proof that your person is at the top of their field. A few other nice items about the O visa is there's no max out date. So once you are granted an O visa, you can request extensions on an unlimited basis. By rule, you're traditionally given an O visa for at least 3 years maximum of 3 years to begin with, and then you would request extensions. It can be 1 year. You can show that the terms of the job have changed when you do your extensions. It gets more and more extensions that are beyond 1 year. You can bring your spouses over and your children on O3 visa status. Unfortunately, they would not be able to work in the U.S., but they are allowed to accompany or to come at a later date through getting a visa at the consulate. The O1 is, again, flexible in that there's not a specific requirement that you have a level of education. So it is open to people who have a bachelor's degree. But if you are of that level of education, you're going to want to show that you're a leader in your field. So if you're dealing with, IT and technology workers, in order to get to an O, you're going to want to see that this person is renowned in their field. Maybe they lead groups that are the experts or the leaders in a certain programming language. Maybe they have been publishing papers. Maybe they are part of groups that are selective. But overall, if you are in a research intensive field, O1 is something that you would want to be looking at if you're not able to get to, not able to be selected in the H-1B lottery.
Great, appreciate the overview, Matthew. Just a couple follow-ups. Similarly, is there a cap on the O1 as there is with the H-1B?
Yes, no cap and no time limit. So the numbers for the O1 are unlimited, and you can apply any time of the year. The level of scrutiny is pretty high, though. So the petition is kind of self-limiting in that you do have to point to at least 3 of 10 criteria that show that you are at the very top of your field of endeavor. So if you are very new in your career and you don't have a great reputation yet, you just haven't established yourself yet, it might not be the option for you.
When looking at the O1, and I'm going to tie it into another visa alternative, we're not specifically talking about it today, but because there's a lot of sporting events going on, there's the P visa. For any employers who might be looking at those, how do they determine, or what's the best way to determine the P visa versus an O visa? O visa, you mentioned, have to be at the top of your field. If you have like a baseball player, today is opening day, arguably the top of their field. How do you kind of look at those options?
The way that you gauge those options are the P visa is generally used for, members of a team or a performing group who are going to be coming to showcase their talents here in the U.S. and need the ability to do so on kind of a longer term basis and be paid in the U.S. O visas are going to be used, more for the star players of your team. If you make it to the professional ranks, your chances of getting to an O visa are pretty good. But if you're not quite there yet, or if your prospects are tenuous, the O visa in the athletic space would be more appropriate for people who are kind of your stars. P visa is generally used for more team members. But going back to it again, typically when we're thinking about H-1B cap selection day and then people not being selected for the cap, we're probably not looking at O-1B so much. We're probably not looking at P visa applicants as much as we're looking at O-1A. So people that would have expertise and experience in research fields, STEM fields, medical fields, these types of professional fields where you're going to put in research and you're going to build accolades that you would put on your resume, and accolades that other experts in your field can speak to. So we'll typically request, minimum of 4, average of 6, even better would be 8 letters from top experts in your field who would, recommend you for this O visa as well.
Gotcha. Matthew, anything else to add on the O1s before we move on to a different alternative?
The O1 is not necessarily dual intent, meaning that it's not the best platform to move on to a green card from. For that reason, people on O, we do see people, reverting back to H-1B, and for other reasons too, keep trying for the lottery in later years. But generally, we are able to, use methods to get people from an O visa to a green card through a couple of different methods.
Gotcha. Let's move on to the TN visa. Again, another alternative. What can you tell us about the TN visa and how employers might utilize it as an H-1B alternative?
Yeah, so the TN visa is going to be pretty limited to 2 citizenship categories, mainly a Mexican citizen or a Canadian citizen. The easiest way to demonstrate the citizenship to the government is looking at the passport. Do they have a Canadian passport? Do they have a Mexican passport? There's essentially 2 ways to apply for the TN visa. Either you file a petition with USCIS requesting that status, or you have the foreign national employee apply for the TN visa abroad. For Mexican citizens, they have to schedule a visa appointment and apply for the TN visa at the U.S. consulate abroad, typically in Mexico. For Canadian citizens, they can apply for the TN visa because they're visa exempt. They don't need to apply for a visa at the consulate. They can apply for the TN visa at the airport pre-flight entry clearance or at a regular port of entry on the U.S.-Canadian border. The other limitation for the TN visa is that it's going to be limited to certain job categories, which are spelled out in a government appendix, which I'll actually paste a link to here in the chat. So there's only certain jobs. Not all jobs are going to qualify for the TN visa, and a lot of these jobs are going to be professional level positions like accountants, lawyers, engineers, and the engineering category is pretty broad. It doesn't have to be a computer engineer. It could be like a mechanical engineer or chemical engineer. Doctors, interior designers is another category, dentists, et cetera, et cetera. So you want to take a look at that list I sent to see which jobs are potentially, and a lot of these jobs are also eligible for the H-1B visa, which is why we're talking about this. But you want to see if you're a foreign national employee would fit under one of these particular TN jobs and meet those criteria. So a lot of these jobs, for example, like the engineer, you have to show that you have a bachelor's degree or a licensed degree or a state provincial license to qualify for that visa. And as a strategy matter, it's good to talk with your immigration attorney about how you want to apply for the TN visa for that foreign national, whether you want to apply for them abroad in Canada at the border or U.S. consulate, or change their status and apply with a petition with USCIS. In either situation, the initial The initial work authorization period is for 3 years, which can also be renewed for 3-year increments indefinitely. There's no cap like an H-1B on the TN visa. You can apply for it any time of year. The other thing that Matthew mentioned is the TN visa, like the ON, is also considered a single intent visa, meaning that it's not the best visa category or platform to apply for a green card process from while you're on that particular visa. So in that situation, sometimes what will happen is companies might switch their Canadian Mexican citizen employee over to the TN and then subsequently register them for the caps in the following years. If they get selected in the cap, switch them over to H-1B and then have them apply for a green card process while they're on H-1B, while they switch over to H-1B. There's no prevailing wage requirement as well, or LCA requirement for the TN visa, like there is with the H-1B. So that's another sort of caveat there.
Anything else to add on the TN? Any other details, things to be on the lookout for?
No, I just, again, you want to really make sure that you're it's limited. Remember, to Mexican, Canadian foreign citizens. You got to make sure that you're under that category. I will say that certain job categories under that TN list that I put there can get some scrutiny, like management analyst and economist, for example. I've heard some stories that consulates and USIS kind of scrutinize those a little heavily. So when you're thinking about that, it's always good to sync up with counsel and make sure your strategy works.
Matthew, back to you. You mentioned, I think when we were discussing some alternatives, you mentioned the E3. And this is the E3 treaty visa, or do I have my names wrong?
Yeah, the E3 visa is a very handy visa. It's done by a treaty with the United States and Australia. So if by chance your foreign national has Australian citizenship, this visa is very handy. It has some of the best aspects of H-1B and the TN visa, in that the visa is open to professionals with going with a degree and going into a position that requires a bachelor's degree at a minimum. It is limited in the fact that you do have to do an LCA. It is going to be limited to 2 years at a time. But it can be renewed indefinitely. You can bring your spouses and your spouse and children over using the E3 visa, and your spouse would be work authorized with no other action needed on your end if they were able to get the E3 visa for the worker. The E3 visa spouse comes over. As long as their I-94 is designated with the letter S for spouse, they can show that to an employer, and they can work as well. Another advantage of the E3 visa is you can actually get it at the consulate. You don't have to go through USCIS and get a petition approved. You can take your documents directly to the consulate. You'd have to work with an attorney to get the appropriate documents, because you will have to file an LCA with the Department of Labor, similar to an H-1B. But you take that, you combine it with the other documents proving the job and the requirements and the qualifications of the applicant. They take that directly to the consulate. Sydney is probably going to be your best bet. And then a visa stamp is placed in that person's passport. They come over and they can start working for you.
What are some of the countries you mentioned? It's like treaties with other countries. What are just a handful of those other countries?
There are a couple of other countries. The TN visa, that's done through a treaty with Mexico and Canada. Also, Singapore and Chile have their own visa types that have been developed. They're similar to the H-1B, called H-1B1. They do have caps on those, numerical caps per year. I've not seen those caps be reached in quite a while. So if you're an HR person and you're scrambling, you're looking for one who can some way to working. If by chance they are born in or they have citizenship in Australia, Chile, Singapore, Canada, Mexico, an item that you should be looking for is one of these visas that comes about via treaty.
You mentioned the H-1B one. I'm wondering if you can talk a little bit about the H-1B one, and you mentioned it's like specific to a handful of countries.
Yeah, the H-1B one, it's it is only available to Singapore and Chile. Again, came about via uh, treaty with those two countries. There is a cap of 5,400 from Singapore per year and a cap of 1,400 from Chile per year. I cannot recall those caps being met. Um, it's is going to be similar to your E3 visa in that you're going to have an LCA. Um, they are issued for 2 years apiece, um, and but there is no max out. So going back to the E3, there's no max out. You can keep renewing that forever. You can also keep renewing this H-1B one forever. Uh, the H-1B one is not dual intent, meaning there's not a great path to a green card from it, but you can bring your spouse and kids on an H-4. Let me see. And another advantage of the H-1B one is that you can do the direct application at the consulate, which in theory would save you both time.
Awesome. I do want to be aware of time. We have about anywhere from 10 to 15 minutes. But there are just a handful of other visa H-1B alternatives. Just wanted to ask everyone about. Then we'll move into the final part of our discussion. Diane, I'm curious. Are there any family-based options that might be positioned as H-1B alternatives?
Right. So the family-based visas are always an alternative, meaning most of my clients usually come to us because there is no family, immediate relative who can sponsor them, so they can only rely on their own skills. But I have to mention one interesting case where a software developer approached us and he was reaching the end of his OPT. He had not been selected in the H-1B and he was considering an extraordinary talent visa category. Actually, he wanted to self-sponsor himself. He wanted to do the EB-1A green card category on his own merit. And I looked at his skills, his publications, his resume, and he didn't quite make the cut. So we looked at all other categories and he really didn't qualify for any other. So at the end of the consultation, I told him, well, unless you have an immediate relative who could sponsor you, there's really no path available to you. And he said, well, actually, I'm engaged to a US citizen. And so I said, well, should have mentioned that right away. We would have saved a whole hour of our time. And he said, no, but for the same reason that I want to do a self-petition for the employment-based green card. I don't want my relative to sponsor me. I really want to get to the green card through my own merit. And I thought it was admirable, but I thought it was not a sound decision because I explained to him that he was a graduate from Stanford. He had an amazing resume. And I said, those diplomas are already attest to your greatness. You don't need USCIS to prove that to you. And also, you never know who the officer who's going to review your file is. You don't know if he's been trained well. There's always a large degree of discretion for those types of applications. And the officer may not understand your field, your achievements. They're not experts. So really, you shouldn't rely on them to tell you how great you are. And if you have a much faster path to the green card and a more certain path, then you should really grab it. And he said, thank you, but no. He insisted. And so we talked about ways that he could bolster. And that's going back to the O1. If you have a potential candidate who hasn't reached the top of their field yet, it's always good to consult with us early. And then we can guide you and them towards what needs to be done for the applicant's profile to be really where it's supposed to be for immigration purposes. So we talked about ways that what he could do for the next 6 to 12 months to bolster his profile. And sure enough, a year later, he actually called me and told me he got married. So I think he realized that it was a much safer path and that it didn't, bear any negative judgment on his own merit. So I think as an HR, if you have a candidate who hasn't been selected and there's no other path, it's always worth asking, do you have an immediate relative? Really, it would be for if they have a parent or a spouse or a child over 21. The other relatives, like brothers and sisters, these would, take forever to lead to an approved visa application.
Appreciate some real life examples. I think that really helps kind of connect everything together and provide some instances of what HRs should be looking, and some of the questions they might want to consider asking. But for the group, as we move on to our final section, I'll start, Peter. I'll start with you. We've been discussing each individual H-1B alternatives and various individual factors that each alternative visa has. But I'm curious, just overall, how do H-1B alternatives fit into a company's larger corporate immigration and mobility program?
Yeah, I think it's a discussion that you want to have with your HR contacts early on, and not really wait until lottery selections are announced. It's good to strategize and look at, okay, these are, have the conversation with your HR and talk about, okay, these are the folks who are thinking about entering in the cap. Let's talk about the consequences if they're not selected in the cap. What are some of these alternatives that we've been discussing that they're eligible for, so that the HRs can start planning for some of these alternatives. Diane talked about the L1, which requires the employee to go abroad and work for the foreign affiliate for at least a year. That's a conversation HR might want to have, so they can start putting those pieces and planning in place, so they can send that employee abroad to that affiliate to fulfill that L1 visa down the road, right? So those are conversations that want to be had. And then also, one thing we didn't mention is the filing fees. The filing fees are going up after April 1st, and they're going to be going up tremendously for most HRs, which is probably the biggest complaint we're seeing. So, in terms of talking about immigration budgets, that's a big topic that a lot of companies want to talk about these days, especially given the current climate and economy. So working with the HR to plan out those budgets and kind of forecast that with them, so they can look good for their superiors and higher ups, and having these alternative strategies. Okay, if we don't get the H-1B, then we got to go with the L or the T, and this is the cost, and this is the cost for these sets of folks who qualify for that. Having those conversations early on in the process is good as well. I'll also say, I feel like the H-1B lottery, even though, it's run in late March, early April, I feel like the whole process in and of itself goes the whole year. And that's not to mention, if there's a subsequent lottery, later this summer, and they decide to run another lottery, more people get selected. These conversations sometimes with bigger companies can go on for the full year in terms of forecasting and trying to figure out alternatives for their employee population. So I think these alternatives are all kind of tools that HR and the companies want to use and figure out and see, okay, if we don't get that H-1B, which employees are going to fit under these categories, and what's that going to cost us, and what's that going to look like, and what is the timetable that we need to meet to make sure we put these alternatives in place in case they don't get the H-1B. So I'll conclude with that.
Yeah. And just really quickly, just confirming, you mentioned the fee increases. A lot of those fees will be increasing April 1st, assuming there's no lawsuit or
injunction, right?
Yeah. Because that didn't a group file a lawsuit like late last week, I think, or last week?
Yeah. I can't remember. I think IT Serve was one of the parties,
Yeah.
and Diana, correct me if I'm wrong, but yeah, there was a lawsuit filed in federal court to enjoin USCIS from imposing those filing fees that are taking effect on April 1st. Last I heard, there hasn't been any injunction issued by the court, so as far as I'm aware, those fees are taking effect on April 1st, unless Diane or Matthew, you know something else on that. And I think everyone is planning for those fees to take effect on April 1st, as far as I know. So
for sure. So Matthew, I'm curious to hear your thoughts on just as well as your insights. When do you encourage employers to examine alternatives?
Well, it's always good to have a backup plan in place before you make the decision to put someone into the H-1B lottery system. You always want to know clearly if they are on OPT, what the end date of their OPT is, if they're eligible for STEM OPT. So probably the best time to consider that is when you're considering putting someone into the H-1B lottery. But right now would be also a very good time. You know, the best time to plant a tree was 20 years ago, but the second best time is now. So if you know we are getting updates about the lottery selections, and you have someone who really needs this and does not have a clear path, you want to start looking at options now and to try to see what what we can do. Um, you know, oftentimes there are ways to get to this person's work authorization that might not have been apparent at the first time. Maybe their spouse has an L and they can have an L2. Maybe their spouse is Australian and they can get to an E3S. And maybe their spouse has an H-1B and has been through the system long enough that they have an I-140 and they'd be eligible for H-4E8. So these are all things that you want to be asking yourself.
Gotcha.
If
Diane.
I can just.
Oh, go ahead. Go ahead.
Yeah, no, you were talking about the spouses. You're right to always consider if the spouse is not a US citizen who can sponsor them, they can also have their own path for a work visa. And I know we didn't talk about the E2 investors category on purpose because it was a little beyond the subject. But the good thing about the E2 investor visa is that the spouse is eligible to work for any employer, which is kind of ironic because the main employee is tied to very strict conditions, but then the spouse can work for anyone he or she wants. So let's say the H-1B potential candidate hasn't been selected, but they have a spouse who may be interested in investing and setting up their own business. They could get the E2, and then the spouse could enjoy work authorization and join that company. So and that all requires pre-planning. And back to what Peter was saying, it's always crucial to plan ahead and contact us ahead if the company really wants to hire a particular candidate, but they don't see any other alternatives. Going back to the L1 really quickly, there was this company based in India. They have a subsidiary in California. They wanted to open a subsidiary in Singapore, send a CFO there for a year, and then have him come over here. And they were very confident about their strategy. But as we were talking during the consultation, it appeared that CFO was planning to come to the US every 3 months for about 2-3 weeks on his B1, B2 to train and coach a team here. So that automatically triggered potential employment that was completely unauthorized under the B1, B2. And they didn't realize, but those 2-3 weeks every 3 months would be deducted from the whole year abroad. So I'm very happy we had that conversation because, like I said, they were very confident. And if they hadn't called me ahead of time, he would have spent a whole year in Singapore only to find out that it wasn't sufficient and they would have to wait additional month. So it's always good to call your attorney early and plan ahead.
Actually, Diane, I was going to ask you that question. Again, really appreciate the story. Again, I think it really helps provide those real life examples. So when do you recommend, or just speaking from your profession as an immigration attorney, when should employers reach out to you and just ask you these types of questions or run things by you? Is earlier better, or we always like to do our own, as they say, do our own research, but like when should people be reaching out to you?
The earlier, the better, honestly. I know it doesn't really fit with companies' urgent needs for workers. Unfortunately, there's theoretically, the earlier, the better. Even like as soon as the candidate is about to graduate, we should, start planning. But the reality for companies is that sometimes they cannot predict the need they're going to have. And when they do have a need for a special worker, they want him or her right now. So there might be a bit of a disconnect between the theory and the practice, but obviously the sooner the better.
Gotcha.
Eric, and I'll just kind of jump in terms of timing of talking about, H-1B cap and, when you want to consider employees and alternatives. I would say a lot of these conversations, and Matt and Diane, I think you might agree, typically around the fall or winter time before the subsequent H-1B cap season, we have these conversations in our calls with HRs, whether that's a weekly or monthly call. Sometimes I'll have a list ready in October or November, and we'll talk about that and maybe go through the list and talk about, okay, if these people aren't selected, can we get them on a TN? Can we offshore them and do an L? Can we do H-1B one? And start really planning that out and discussing these alternatives with them. That's a good strategy and approach, and I think that's typically when a lot of these conversations might happen. So.
Yeah, appreciate it. Well, in this about final minute or so, I think we'll just end with some words of wisdom, final remarks, maybe anything that we missed that anyone wants to share. Matthew, we'll start with you. Any, just words of wisdom on H-1B alternatives or things that we missed that you just want to quickly shout out?
I would just advise you to take a step back, analyze, your needs for this position, analyze the qualifications of your candidates, and as you can, ask to see or explore if they have, a relative or another path. The not being selected in the cap is not the end of the world. It doesn't have to be the end of your immigration journey, and it can be. It can lead you down a path that might end up being even more advantageous for you.
Diane?
Yeah, just a remark regarding the bit of a conflict sometimes we as attorneys have between advising the company and the foreign national. Obviously, the companies, when they are looking to hire a worker, their best interest is for that worker to remain with the company. So that's why principally they're looking at non-immigrant visas such as the H-1B or L-1. But the foreign national, in most cases, their ultimate goal is to get to the green card. But that would mean that they're free to work for another company. So sometimes, just a quick example, I had this O1 worker, the company sponsored him. He applied for an EB1, which is green card in outstanding achievement. The company sponsored him, but they didn't want to pay the premium processing fee. They were not in a rush. He still had 3 years ahead of him in the O1 category. Ultimately, he was approved, but there was the retrogression for the green cards. So he couldn't get his green card, and now he has to renew his O1. So the company is subject to immigration fees all over again. So that's why I know it's kind of short to explain this whole situation, but companies who think it's not in their best interest for their worker to get to the green card may actually, if they want to retain that employee, it may actually be the best path for everyone, because applying for multiple non-immigrant visas over and over again may cost just as much down the road.
And Peter, any words of wisdom?
Yeah, start the planning process early and identifying those employees that you want to register for the H-1B cap. If you don't already have competent immigration counsel to guide your employees and yourself and your immigration program through that journey and process, wise to do so. It can be complex at times. And just know that, I feel like USCIS is always tinkering with this H-1B cap selection process. We went from a paper-based system where, Matthew, Diane, and myself are submitting a bunch of petitions and loading them up on the FedEx boxes to a online cloud registration system. And even this year, they've tinkered with it further, causing some angst and consternation with attorneys in terms of being able to log in and getting access and that sort of thing. So you need to exercise some patience there. USCIS is always tinkering with the technology, and it is an election year. So if the alternate happens and Joe Biden is not president next year, more sort of to come on cap for next year. So we'll see how that would work. So yeah.
Yes, always something's always changing. So we'll see. And we'll
exercise some patience. Yeah,
and we'll definitely keep everyone updated. Well, Matthew, Diane, Peter, want to thank you all for hopping on today's LinkedIn live session. I know we've gone a little bit over, so appreciate the extra time from everyone. And to all our attendees, whether you're watching live or you're watching this, recording at a later date, appreciate you tuning in. Be sure to follow us on LinkedIn as well as our other social channels, as well as you can follow Matthew, Diane, and Peter on their own LinkedIn channels. Check out envoyglobal.com as well as Corporate Immigration Partners.